A courtroom door opens. Sunlight cuts across wooden benches. A defendant sits at a table, hands folded, while a clerk reads aloud, the charges specific and numbered so that everyone in the room, including the person accused, knows exactly what conduct is at issue. No vague whispers, no secret allegations. The clarity is absolute. This is where the Sixth Amendment lives, not in a history book but here in the stillness before testimony begins. The framers had watched trials in England where the machinery of prosecution belonged entirely to the crown. The accused was a subject without voice, often without warning of what they would answer for. They built the Sixth Amendment as a set of interlocking safeguards against that kind of power running unchecked. Start with the charge itself. It must be stated clearly, in writing, so the defendant understands what they're defending against. Everything else, the entire architecture of the trial rests on this foundation. You cannot prepare a defense against fog. Then comes the calendar. Criminal trials cannot drag on indefinitely. The phrase speedy trial entered the amendment because delay itself was a weapon. A witness's memory fades. Someone sitting in custody for months loses their livelihood, their home. Accusers disappear or vanish before they can testify. The right sets a boundary against this slow erosion. The state must move or let the accused go. But speed means nothing if the person facing trial stands alone against the machinery of law. The Sixth Amendment guarantees counsel, either someone the defendant can afford to hire or, if they cannot, someone the state must provide. This is not charity. It is recognition that the legal system is asymmetrical. One side writes the rules and prosecutes. The other needs someone who knows those rules well enough to contest them. 12 people sit in a jury box. They are drawn from the community. Neither the judge nor the prosecutor is judge alone. Their job is to weigh the evidence presented and decide guilt or innocence. This distribution of authority was deliberate. Power that cannot be concentrated easily cannot become tyranny, and the accuser must appear in person, not a written statement read into the record, not an unseen witness. The defendant's lawyer can cross-examine them, test their memory, their bias, their reason for speaking. They speak under oath, subject to questioning. Conviction based on invisible or unexamined sources was the old way, the Crown's way. This amendment forbade it. All 6 protections reinforce each other. A speedy trial gives counsel time to prepare. The jury means the accused is not alone. Confrontation means witnesses are tested, and the entire proceeding happens in open court. Secrecy was the tool of oppression. Sunlight on the proceedings is itself protection. The public witnesses whether justice is being done. These rights exist in constant negotiation with the state's legitimate interest in prosecuting crime. They are not obstacles to justice. They are the shape that fair justice must take.